Good afternoon. Good afternoon, all. Very good. Okay, so we were discussing Article 32. Just share the screen and then we'll start the discussion. Okay. So Article 32, as we said, is the soul of the Constitution. And we discussed the 3 points under Article 32. The first is whenever fundamental right is violated, you can directly go to the Supreme Court. The Supreme Court only will be listening to the fundamental right violation cases and issue writs. And it is mandatory for Supreme Court to listen to fundamental right violation cases, not for the High Court. And we saw that there is no locus standi, there is no technicalities, and suo motu action can be carried out in fundamental right violation cases. Now, with respect to writ jurisdiction, Supreme Court can issue writ for fundamental right violation, whereas High Court can issue writ for fundamental right violation and HR violation. High Court can issue writ for fundamental right violation and high legal right violation. Okay, sorry, it's not HR, it is LR. What is a legal right? There are certain rights apart from Part 3 of the Constitution, right? These are called as constitutional legal rights. To implement that, you can go to the High Court directly. For example, right to property is there, right to vote is there, right not to be taxed without the authority of law is there, then right to do free trade and commerce between the states. So any of these issues, any of these rights is violated, you can go to the High Court. Okay, now why Supreme Court only fundamental right violation? Because if you say that for legal right violation also you can go to the Supreme Court, a lot of cases will be overloaded in the Supreme Court. We don't want that to happen. We want to ensure that Supreme Court is listening to the most important cases. Okay, it's original jurisdiction and fundamental right violation cases. Sorry. Okay. Now let us talk about each of the concepts. Habeas corpus. Habeas corpus. The literal meaning of the word habeas corpus means to have the body of. Okay. Corpus means body, habeas means to have the body. But the meaning is to ensure the produce of a person. Okay. Or I would say whenever there is a case of illegal detention. Illegal detention. I'll talk about what is illegal detention. Before that, whenever there is a case of illegal detention, if you want to save a person from that illegal detention, we can go by filing the habeas corpus petition. Okay, so if this habeas corpus petition is filed, the police has to ensure the person is present before the court of law. And if it is illegal detention, the person will be freed. Now, some of you may ask, sir, to have the body means whether the person should be alive or not. The person should be alive only. Okay. Just its literal meaning is to have the body of. The police should ensure the person should be alive and produced before the court of law. If it is illegal detention, the person will be freed. What do you mean by illegal detention? Okay, we saw yesterday, yes, that whenever a person is arrested, the person should be produced before the magistrate within 24 hours. Just assume that one of your friend is being arrested, but not produced before the magistrate within 24 hours, which means that your friend is being illegally detained because no permission from the court of law. It's not a legal detention. So you can file a habeas corpus petition and force the police to produce the person before the court of law and ensure his freedom. Okay, so this is first type of illegal detention. Second, what if the police is getting the permission from the judiciary? The judiciary says, okay, you have to keep this person in the lockup, or you have to keep the person in the sub jail. Like that, judiciary is giving a instruction. But the person is kept in a undisclosed location, okay, or an unauthorized location which is not set by the court of law. So the police is keeping the person's custody, in some other place. Okay, so then that is also called as illegal detention, because a legal detention is one. Not only court should give permission for your detention, but also the location of the detention should be available. That is why when relatives, okay, wants to see your friends, okay, our relatives want to see the person who is detained, the police has to show the person. If the police says that no, the person we cannot show, you can file a habeas corpus petition. Okay, now what if your friend is arrested and permission is got from the court of law, and he's in the disclosed location only, known location only. But when you go to see him, you find that the person is being subjected to custodial torture. Okay, you see some wounds, and your friend is saying that the police is beating your friend. Now you can file a habeas corpus petition to identify whether it has really happened or not. Okay, so illegal detention is when court's permission is not there, or a person is in undisclosed location, or a person is subjected to custodial torture. Now, illegal detention is not only can be carried out by the police, it can be also carried out by the private people. Supposing there is an intercaste marriage or interreligious marriage. In case of intercaste marriage or interreligious marriage, okay, there is a chance that the parents of one of the spouses may keep the custody of the person, or lock the person in a room. That is called as illegal detention. In that case, also habeas corpus petition can be filed. The child custody cases, suppose there is a couple who is conflicting. Suddenly one couple is taking the custody of the child. Okay, the other person can file a habeas corpus petition. Okay, so in child custody cases also habeas corpus petition can be filed. So remember, okay, so one of you are asking why court is not responding to habeas corpus petition. I'll explain that why. Okay, now in case of illegal detention, habeas corpus petition will be filed. But you must show prima facie that it is a illegal detention. Prima facie means at the first look. You must be able to tell who might have subjected to illegal detention. For example, there is a missing case. Suddenly you find that one of your relative or friend is missing. You cannot file habeas corpus petition. It is a missing case. You should file complaint only with the police, because sometimes people might have gone themselves, to some other place. Some people, they get frustrated out of life. Okay, so just imagine Donald Trump. By the time he should have been frustrated, feeling bad about himself, so he'll want to go somewhere else. like that. Okay, if a person feels that he's feeling bad about his life, so they can go voluntarily also. So illegal detention means you must clearly know who is illegally detaining, whether it's a police or a particular private person. Then you should file a habeas corpus petition. So for missing cases, we can't use the habeas corpus. Missing cases you cannot do. But when children are missing, no, or mentally challenged people are missing, then you can file the habeas corpus petition, because these people cannot decide for themselves anyway if they are going to be in custody of somebody else, even though you cannot exactly pinpoint who has kidnapped them, okay, who has taken away their custody. You are allowed to file the habeas corpus petition. So wherever there is a case of illegal detention, habeas corpus petition can be filed. This is to ensure that the police is not misusing their power of arrest to put a person inside a undisclosed location or subject them to custodial. Okay. Or supposing a police is your neighbor just to threaten you, they capturing one of your relative and putting inside the prison. You have a remedy in the court of law. Okay. Where habeas corpus may not be applicable, we have to see. Habeas corpus is not applicable. Okay, there's an interesting question, sir. Is this applicable for even terrorists? Sometimes the locations are not disclosed, right? See, uh, for example, yeah, there is a terrorist. You are putting the person inside the prison. For the relatives of the terrorist, they know where the person will be kept. Okay, you cannot, even a terrorist, no, you cannot keep even uh, the person involved in the gunning in Mumbai terror attack, Kasab. Okay, so he also was kept in a known location only. Now, if for public purposes, if they don't want to know the location within the prison itself, they will have an isolatory cell, and they would have got permission from the court of law. The court would appoint a representative to ensure the person is protected inside the prison. Then what will happen is army and police will mention anybody as a terrorist and place them in an undisclosed location. So if they are placing in an undisclosed location, it is a case of illegal detention. Okay. So where habeas corpus is not applicable. First point is preventive detention. Because preventive detention is a legal detention. Okay, you know the location of the person, and the reason has also been told. So you cannot file habeas corpus petition in a preventive detention case. Now you may ask, sir, what if, sir, in preventive detention they are subjecting the person to any custodial torture? In that case, also you can file habeas corpus, but you must prima facie show the evidence. Okay. Then legal arrest. Okay, any kind of legal detention. Okay, which is a product of court order. Okay, legal detention. Okay, is if it is a product of a court order. Okay. Habeas corpus petition, no? It cannot be applied for regular detention. Okay. If a person is convicted, punitive detention is done. You have done a wrong, so because of the wrong, you have been sent to the jail. At that time, habeas corpus petition is not applicable. Okay. Now, we have to ask questions. during national emergency, whether habeas corpus is applicable or not. We know that during national emergency, fundamental rights can be restricted. So what about the habeas corpus? Make a guess. Yeah, generally we may think it is not applicable. You're right. Before 1978, it was not applicable, habeas corpus petition, because Article 20 and 21 also can be suspended. But after 1978, 44th Amendment Act, Article 2021 can never be suspended. 20, you know, that, you know, rights with respect to conviction for offenses. Article 21, right to life and liberty. Okay. So which means if somebody is subjected to illegal detention, even during national emergency, they can use habeas corpus petition. Habeas corpus petition can be used to protect them. After 1978, 44th Amendment Act. Because Article 2021 is made non-suspendable at all. It remains there all the time. Okay. What about, okay, those area where AFSPA is there? AFSPA means Armed Forces Special Power Act. There also, you know, habeas corpus petition is applicable. Okay, AFSPA is only giving immunity. Okay, armed forces, it gives immunity to armed forces only. Okay, it does not allow the army or police to have illegal detention. So then also it is applicable. Oh, what is the Armed Forces Special Power Act? Okay, it indemnifies the act of armed forces. See, normally if police or army kills a civilian, they'll be subjected to prosecution. It's no different. Army or police, if they're killing a civilian, okay, they will be subjected to prosecution, and then only court will find whether it is correct or not. Okay. But in case of disturbed area, for example, terrorists are hiding in a home. Now armed forces and police is entering into the home. Okay, they have to fire at the terrorists. But inside the home there may be civilians. So if the civilians are dead in the line of fire, can the army people or police people can be subjected to prosecution? No. If you do that, it will demoralize the armed persons and police personnel. They will not shoot at the terrorist. Okay, they refrain from shooting because they may be prosecuted. Because the terrorists may be in the form of civilians, or civilians may be dressed up the terrorists. Any option may be there. Okay, so Armed Forces Special Power Act, it indemnifies the act of armed forces, meaning the armed forces will not be prosecuted. Okay, some of you may ask, sir, what is indemnification, sir? Okay, in insurance industry and all, you know what is indemnification. Suppose you buy a car and the car meets up with a small accident. The car is already has insurance. What is happening is, okay, whatever amount that is occurring for the repair of the car, you will be neither at profit, neither at loss. The insurance company will give you an amount to repair the car only. So you can come back to normal situation. Okay, you are not meeting up with loss. Insurance can never be a profit. Okay, insurance will not give you a profit. It will place you in the same condition. That is called as indemnification. Neither at profit, neither at loss. You will be back to the correct position, even if you are facing loss. Okay, likewise, army people, whenever they involve in act, if civilian is affected, okay, they will be not prosecuted. They will be in the normal situation. But that doesn't allow the army or the police to go for illegal detention. So that is why habeas corpus is applicable even in areas where Armed Forces Special Power Act is there. Okay. Then we have martial law. Okay, don't confuse it with marital laws. Marital laws means marriage laws. Martial law means military rule. Some of you may be saying, sir, both are same only. But anyhow, martial law means military rule, and you should not confuse martial law with AFSPA or national emergency. It is completely different. And martial law, you should not confuse it with military coup. What is a military coup? Okay, so when the government is taken down by the military and military takes over the administration of entire country. In Pakistan, it happened. In Egypt, it happened. In India's case, no. Okay, it has never happened. That is military coup. Martial law is in a small place in India, within India, in a particular place is disturbed area, the government may send the military and ask the civil administration to be replaced by military. So the civil administration will be completely taken away. They'll ask to come back, and military will be asked to go and work. Yeah. Okay, so it's not a military coup, nor civilian administration is replaced. And who announces this military law, martial law, or military rule? It is done by the central government, and the military rule will be conducted under the central government. So remember, martial law is that is declared to a small area only and under the central government only. Civil administration is replaced in that local area. Okay. So far in India, martial law has not been declared. So they have not said whether habeas corpus will be applicable there or not. Only when you are creating a martial law, we're talking about what are the fundamental rights is suspended there. Then after, we will be seeing whether habeas corpus is applicable or not. Since martial law has never been implemented, okay, there's no question that has arisen whether habeas corpus is applicable or not. But by logic, Article 21, right to life, is very important. So when during national emergency, habeas corpus is applicable, martial law also, it should be applicable. By logic only we are saying, okay, it's not written anywhere. Okay. See, in the international level, whenever the international community is asking question to India about the Jammu and Kashmir position, we can easily defend that, in case of Jammu and Kashmir, even though there is it has been converted into union territory, even though it has been converted into a virtual, sub-state under India, okay, even though Jammu and Kashmir is under army and the police cover, habeas corpus is still applicable there. Okay, so we need not fear that people of Jammu and Kashmir will be eliminated overnight by the Indian government. So habeas corpus is applicable even in insurgency areas. Okay, national emergency, AFSPA, martial law, insurgency areas, in all places, habeas corpus is applicable. Okay, who can file this habeas corpus petition? Initially, the relatives of the affected party only can file the case, but now they've extended anybody can file a case, okay, for retrieving the person. A habeas corpus petition can be filed by anybody, third party also. So they have evolved. Okay. As I told you, judiciary is not applying a no locus standi principle. That way they are evolved. Okay, so habeas corpus is over. Okay. Now, some of the courts, when habeas corpus petition is applied, they will be rejecting habeas corpus petition because, the court may not be convinced, okay, that the person has been taken into illegal custody. So it is the discretion of the court, okay, to allow for habeas corpus or not. I told you now for children and mentally challenged people, court is allowing for habeas corpus petition. That was introduced by Madras High Court and followed by other courts also. Okay. Now let us talk about mandamus. The word mandamus means we command. Who commands? When we see we command, who commands? The judiciary commands. Judiciary commands whom? The executive and the legislature. Okay. Either the court will ask something to be done. Either they can ask something to be done, or they can refrain. They can ask the executive and the legislature to refrain from an activity. Okay, because sometimes when government does something, it may violate the fundamental right. Sometimes by not doing a certain thing, they may refrain the fundamental rights. So accordingly, there will be instruction, okay, whether to involve in a particular act or not. Okay, fine. Any doubts? Any doubts? Okay. Now, mandamus is the most frequently used writ. Okay. Almost all the fundamental rights. Now, when you see, whenever a fundamental right is issued, when you cannot issue it in any of the writs, mandamus will be used. Sometimes mandamus is also used for legal rights also. Court has extended that for legal rights also. Okay. Indian courts are, paradoxical. Okay. Constitution will say one thing, they will do one thing. Okay. So Indian courts have started issuing mandamus for legal rights also. Then, since mandamus is applicable to all the fundamental rights, okay, it is applicable only against the state, okay, not against private individual. And moreover, since it's frequently used writ, let us see where it is not applicable. The logic is, if you know where and all mandamus is not applicable, in rest of the areas it is applicable. So that is the reason why We are seeing where mandamus is not applicable. Mandamus is not applicable, okay, against the president or the governor. What is the logic? The president office and the governor office is the topmost office, right? If you are going to issue a mandamus to them, it will be undermining their office. And moreover, who takes the decision? The president or prime minister, governor or chief minister? It is a prime minister or chief minister and the council of ministers take the decision. So if at all the court wants to do something, they will send order to the ministers and prime ministers or chief minister, to the government, not to the governor or president. Okay, because president and governor, they do not take decision by themselves. Okay, so which means, okay, the mandamus cannot be issued against president or the governor, but it can be issued against government, meaning the prime minister and his council of ministers or chief minister and his council of ministers. Yeah, it is not applicable against the president or the governor. Mandamus is not applicable. Mandamus is not applicable against private individual. Who can violate your fundamental rights basically? Mostly the state only. So the mandamus is issued against the state, that is government and legislature, not against the private individual. Mandamus cannot be issued against Chief Justice of High Court. See, when I say mandamus cannot be issued to Chief Justice of High Court, it means that the habeas corpus, the mandamus writ can be issued to lower courts, including the judges of the High Court. But Chief Justice of High Court is a constitutional office, so you cannot send mandamus to him. Now, anybody tell me, what about Supreme Court? Whether mandamus can be issued by a Supreme Court? What is the nature of mandamus? It is giving order for performance of a duty. Okay, whether Supreme Court is subjected to mandamus? Think logically and try to answer me. Yes, waiting in the chat box. Very good, Vamshi. It cannot give order to itself. See, the Supreme Court is the topmost body. If it wants to do something and implement fundamental right or refrain something so that fundamental rights is ensured, it will do by itself. Order is issued from a higher authority to a lower authority. So Supreme Court is the highest most authority, so it cannot issue writ against itself, mandamus against itself. It will do by itself, but it can issue writs to High Court judges. It can issue writs to High Court judges, but not to the Chief Justice of High Court because of his constitutional office. Then, okay, departmental instructions. You cannot issue mandamus for departmental instruction. What is a departmental instruction? Suppose you are the secretary to the government of India and you are introducing some administrative measures in your department, okay, to make your administration efficient. But you are transferred to some other department, other person is coming, is cancelling out all the instructions that is given by you. Whether those departmental instructions can be filed in the court of law, telling that mandamus should be issued. No, it should not be done. So your departmental instruction is a bureaucratic rule. Okay, it can be done away with. You cannot go to the court to make it implement. Now, some of you may ask, sir, what if the departmental instruction is affecting the caste? Okay, based on discrimination, we can strike it out. What if the departmental instruction is done that is disfavorable to the SCs and STs? That can be filed under Article 17. Okay, so here departmental instructions is not subject to judicial review. Then contractual obligations that will come at the end. Discretionary functions. Discretionary. What do you mean by discretionary functions? See, supposing you are a district collector, supposing you are a district collector, now it is the district collector's duty to give the ST certificate. Okay, it's a duty, but you have to give it only to those people who are deserving. You should assess their background and identify whether they are tribal or not. Then only SC status, scheduled tribe status should be given. Now, just assume that a person is giving a petition for ST certificate. Now, as a district collector, you are going through it and saying that, it seems that, all your records doesn't show that you are a tribal person, so I'm striking it down. Now, this affected fellow cannot go to the court of law and ask the collector to sign the certificate. Executive will not, judiciary will not do that. But if supposing the same person is coming and petitioning you, you're not even opening the letter. Okay, you are just not taking any action. Okay, in that case, the government or the police, higher authorities or the police or the judiciary, they can request you to perform the that particular function, because it is mandatory for the district collector to consider the petition. You not even consider, you have kept a file here and you're delaying. Okay, then mandamus can be issued to ensure that the collector is fastly look into the file. But at the end of the day, who's having the discretion? The district collector only has the discretion. So departmental section and discretionary functions. Contractual obligations. What do we mean by contractual obligations? Supposing you are a district collector and you are giving a road contract, telling the road contractor that if he is finishing in time and with best quality, you will pay the full amount. But before that, within a slot, okay, what you will say is first 50,000 or 50% of the total money will be paid. Only when you are satisfied to do the work, will pay the remaining. Like that, you'll say. The person is constructing the road and is coming back to you. You find that road is not laid properly, so you're saying that the remaining 50,000 I will not give you. Now, this is breach of contract. Okay, as per the contract, the IAS officer, the district collector, has accepted for the entire plan. Okay, what is the contractual obligation of the seller? He has to give keys in time. He should not delay. Okay, so now both of them has breached the contractual obligation. Where it should go. Okay, it should go to an ordinary court only. It should not come under mandamus. It should not come under mandamus. No, see, there are many discretionary functions for many authorities. I gave one example for collector. Other people also have discretion. Yes. Yes, one person is asking, said Salem 8-way road. Okay, if a person is feeling it is bad, okay, can they go to the court of law? Yes, you can petition. But it is up to the judiciary to take up the petition or not. That is where the check is. Because everyone will be filing a case against everyone, that will be a backlog. Okay, so judiciary decides whether it is important case, whether important people are to be protected, and then they will go for the approach. Give me 2 minutes now, just come. Okay. So these are the areas in which mandamus is not applicable. In all other areas, you can use mandamus. Mandamus is the most used writ. Now, habeas corpus is linked to which article? Yes, and tell me now, which article of fundamental rights is linked to habeas corpus? Habeas corpus ensures that there is no illegal detention. So absence of illegal detention means which fundamental right is protected? Give me the answer. Article 21. Article 21. Very good. Right to life and liberty. Okay. So now you just discussed, no? Just a minute. Now next is prohibition and certiorari. Prohibition and certiorari. Now, what is common between prohibition and certiorari? It is issued to a lower court. When I say lower court, it involves tribunals also. Why it should be issued to a lower court? Sometimes a lower court may take up a case beyond its competence, beyond its power. See, already we have said, no, in case of Sessions Court, It can listen cases up to or more than 7 years, right? Sessions court more than 7 years. Okay, death penalty. Like the next level of court is Chief Judicial Magistrate Court. Chief Judicial Magistrate Court. Okay. They can deal with cases up to 7 years. Then we have Judicial Magistrate Court. Judicial Magistrate Court. Okay, so they can deal cases, up to 3 years. We know this already, right? What if Judicial Magistrate Court takes up a case that is involving death penalty? See, why this demarcation they have given? A Judicial Magistrate Court, no, the judge will be of less experience. He's a new judge. Chief Judicial Magistrate Court, more experience. Sessions Court, well experienced. So higher and serious cases has to go to an experienced judge. Now, what if lowest most court judge with low experience, Judicial Magistrate Court, they are taking up a death penalty case? He may give a wrong judgment. So right to life of an individual may be affected. So in case if lower judiciary is taking up a case beyond its power, then the Supreme Court and High Court can issue both prohibition and certiorari, stop the lower court from listening to the case, and they'll take back the case to them. So it is up to 3 years. Okay, Judicial Magistrate Court up to 3 years. Okay. See, in village and all this happens. Okay, whenever some murder case takes place, supposing some two families is fighting and unwarrantedly a murder is taking place, nobody goes and tells the police. Okay, they will complete it as a normal case. Okay, if there is some compensation paid, they will pay and say okay, because they will think that the person who has committed the murder, his life will be wasted. Likewise, sometimes when a murder case is taking place, even the police is knowing, influential people will give money to the police and they may file a case in the lowest most court, and they can easily manipulate the lowest most judge and get a favorable judgment, and innocent persons may be affected. Real perpetrators of the crime may escape. So that is why courts must be listening to the case in which it is having jurisdiction, power, competence. Okay, now here the word jurisdiction means what? Area over which power can be exercised. Okay, so each court has jurisdiction. For example, Sessions Court jurisdiction is more than 7 years and death penalty. Okay, so all the courts should stick with this jurisdiction. You may be asking, sir, how could we identify that a particular case will invite this much of punishment? In IPC, they have clearly given what is the minimum punishment, maximum punishment. They'll take the maximum punishment. Okay, so if a particular case, maximum 6 years punishment, it will go to Chief Judicial Magistrate Court. If a particular case is maximum punishment is 2 years, it can go to the Judicial Magistrate Court. But if a case Minimum punishment itself is 7 years plus, more than 7 years. Okay, and maximum punishment is death penalty. It can go to the sessions court. So based on that, they'll identify whether the court has taken up a case within its competence or beyond its competence. So both prohibition statutory is issued to a lower court, and they are issued to judicial and quasi-judicial bodies. Judicial and quasi-judicial bodies. Yeah, district and session courts are quite different because district civil court deals with civil cases. Sessions court are the district level courts which deals with criminal cases. So sessions court is for criminal cases. Okay, judicial and quasi-judicial bodies. Judicial bodies we know. Okay, the court of law is a judicial body that we know. So what is quasi-judicial bodies? Quasi-judicial bodies means there are three types of quasi-judicial bodies. First is they will be dealing with specific type of problems. Normally a judicial body, they deal with conflicts, okay, of various range. Okay, all types of conflicts judicial bodies will deal with. But there are some judicial bodies which will deal with specific types of problems. For example, National Green Tribunal, Administrative Tribunal. Okay, so they are called as quasi-judicial bodies. When a body deals with a specific type of problem, they are called as quasi-judicial bodies. There's another type of quasi-judicial bodies are there. Their main function would be something else. Okay, like election commission. Okay, for election commission, the main function is to conduct the elections. But when it comes to dispute between two political parties of electoral symbols or two factions for the electoral symbol, at that time who declares or who resolves the dispute, it is the election commission. So if the election commission resolves the dispute between two political parties, then they act as a judicial body there. So they are also a quasi-judicial body. Okay, so whenever they act in judgment, and there is a third provision that there are certain bodies which has the powers of civil court. For example, National Human Rights Commission. They can call the officers to come and depose before them. They can demand documents to be submitted to them. Okay, so in that case, we will be telling that, this is also a quasi-judicial body. The National Human Rights Commission is also a quasi-judicial body. So quasi-judicial bodies are of three types. One is when they deal with specific type of problems. Second type of quasi-judicial body, their main work will be something else other than adjudication, but one of the work will be judicial work. Third is those institutions which is having the power of the civil court. Okay, so the prohibition and statutory can be issued against for judicial and quasi-judicial bodies. Now, prohibition is issued before the initiation of proceedings. Okay, prohibition is before the initiation of proceedings. But in case of certiorari, okay, before no, it can be issued after final judgment. See, the High Court may come to know that the lower court is taken up the case beyond its power, even before the initiation of proceedings. Just now, the lower court has taken up the case, and High Court knows that, so High Court will stop the lower court and take up the case to itself. That is called as prohibition. The word itself there, no, prohibition, prohibit the lower court from hearing a case. Okay, case is not initiated. But what if a case has been taken by the lower court and final judgment also has been delivered? Okay, now in that case, the High Court will issue a certiorari. The meaning of the word certiorari means certificate. Why the certificate has to be issued? The High Court will issue the certificate to say that the judgment given by the lower court is not valid. It is quashed. And then High Court will ask the lower court to ask the case to be transferred to the appropriate court. Okay, so prohibition is before the initiation of proceedings, certiorari is issued after the final judgment. No, see, the person has to run the case only in the appropriate court. Now, one of you, as Kunal has asked, so what if the person is not able to run the case in the higher court? See, criminal cases are run in the courts by police. Okay, so the problem is with the police. You have to go and defend only. Okay, so there's no expenditure for defense. So anyway, any court, you will have the same expenditure for the defense. So the person shall be, taking up the case in the appropriate court only. Okay. So certiorari is there to tell that the judgment is cancelled and then they are taking up. So prohibition, we can say that it is preventive. Okay, certiorari, we can say that it is preventive as well as curative. It's preventive as well as curative. Okay, it is preventive as well as curative. Now, what is the meaning preventive? That is, even before the case is being taken up, you are preventing the case from being continued by a lower court, you are taking it up. Whereas certiorari, it is curative, means after the final judgment is coming, you are quashing the judgment and taking up the case. So it is a cure. Now, why we are calling certiorari as preventive as well as curative? Because sometimes immediately after the case has started, the proceedings might not have been complete. Final judgment has not come, but they will give interim judgments, interim orders. So if in a case, if interim orders are there, there is no use of prohibition because already orders have been issued. You have to squash that orders also. So a case which is not complete, only interim orders is passed, and that case is undertaken by a lower court without competence, then the High Court can squash the interim orders and take the case and give it to the appropriate court. Prohibition is not applicable to administrative decisions. But certiorari is applicable. Administrative decisions. Applicable to administrative decisions. Okay, now why prohibition is not applicable to administrative decisions, but certiorari is applicable to administrative decisions? See, supposing a person, see, ST certificate has to be given by the district collector. Okay, it is his discretion, as I told you already. Supposing you're going and filing a petition, okay, asking, please give me the ST certificate. But you are filing the petition to the Tahsildar. Tahsildar should not decide it. Okay. Now, just because you have submitted it to the Tahsildar, you cannot issue prohibition. The Tahsildar will open the petition and see, okay, this decision should be taken by collector, so he will move it to the collector. Okay. Now, what if the Tahsildar himself is deciding and issuing the ST certificate? Then we are sure that the Tahsildar has taken a decision beyond his competence. See, in case of court cases, we can easily identify which case should be going to which court. So jurisdiction problem easily we can identify. So prohibition is possible. But in case of administrative decision, we don't know whether a decision has been taken by the incompetent authority unless the decision is taken. One decision has to be taken, then only you know whether the person is competent or not. If the decision is not taken yet, how can you know whether who has taken the decision or whether the person is competent or not? No, because decision has not been made. So prohibition is to prohibit a final thing to come, right? It is issued before the initiation of any proceeding. Okay, so prohibition cannot be given for administrative decisions, but it is applicable for administrative decisions because once the administrative decision is taken, you know who has taken the decision, whether he is competent or not. If the decision is taken by an incompetent authority, it can be stuck down and the decision can be shifted to the competent authority. Decision is not being taken, nothing can be done. That is what certiorari is applicable to administrative decision. And this is, okay, judicial innovation. Just remember, okay, this point applicable to administrative decisions. No, the constitution does not say anything. Okay, judiciary has started applying certiorari to administrative decision. So it is a judiciary's innovation or judiciary's introduction to the Indian constitution. And now we have to see where prohibition and certiorari is not applicable. Certiorari and where it is not applicable, we have to see. First, it is not applicable against private individual. Okay, because private individuals do not sit in judgment. So no talking about taking a case beyond the competence. It is not applicable against legislature. Why prohibition and statutory is not applicable against legislature? Anyway, the legislature after passing the law, it is the judiciary which will check whether the law is valid or not. Now, if you allow prohibition and statutory in case of legislature, okay, just imagine, no, even before the final law is coming, the judiciary will issuing the prohibition. Okay, so if there is any flaw in the law, finally, anyway, Lok Sabha and Rajya Sabha will rectify the flaw and then only they'll pass it. So when the bill is in the process, when the law is in the process of drafting, no intervention should be there. That is why, prohibition and statutory cannot be issued against any legislature, both parliament as well as the state legislative assembly. Then any doubts? No, it won't affect the moral of law. See, in India, we have integrated judiciary. She is asking whether this statutory and prohibition will affect the moral of lower court. No, because lower court are destined to take up only appropriate cases. Okay, if they are taking a case beyond its power allocated in the constitution, allocated in the law, then the lower court has to accept the high court's decision, and lower courts come under the high court's control and superintendence. So if you see, Indian judiciary is an integrated judiciary, so lower court has to go by the control and dictates of the high court. Okay, next is we have to talk about the double opinion. Actually, you may be asking, sir, anyway, appeal is there, no? No, 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 no. The judicial review of law cannot be called as a certiorari. Okay, certiorari is different. Okay, judicial review is different. Okay, so in case of certiorari, you are quashing the law and asking the appropriate authority to make law or make the decision. Okay, but in case of judicial review, you are just striking down the law. That's all. The law will not be reconsidered. Okay, so judicial review is different, certiorari is different. Very good. Okay, Gunal has asked a relevant question. Why these two, prohibition and certiorari, are that much important? To say it is soul of the constitution. So I told you, no, suppose there is a death penalty case. It should be heard by the highest most judiciary. But if the lowest court, okay, is listening to death penalty case beyond its competence, the person who is accused may be wrongly judged and his life may be taken away. He may be subjected to death penalty. He may be imprisoned. So right to life and liberty may be taken away. Okay, so that is why lowest most court cannot, or lower courts cannot take a case beyond its competence. The word beyond its competence is very important, meaning beyond its power. Okay, if the case should not go to the court, it should not go to the court. Okay, so otherwise our police will file cases in the lower court, easily manipulate and finish the case easily. That is the reason why it is under the soul of the constitution. Okay, in case of certiorari, you may be asking, sir, there is appeal, no, sir. then anyway, if lower court is taking a case beyond its power, okay, you can still file a case in the higher court and then get the remedy, right? Then why should we have a special tool called as certiorari or prohibition? It's simple. There is in judiciary they follow the principle of second opinion, meaning first time a court is giving a judgment, after that you are going for a first appeal. First appeal will be automatic because only one opinion has been given. Okay, so first appeal will be automatic. It's also giving a judgment. Okay, whether you can once again apply it to a higher court. Supposing you are filing a case in the Chief Judicial Magistrate Court, from that session court you are going. Sessions court is giving a judgment. You are not satisfied with the judgment, whether you can go to the High Court. Yes, but only when the first opinion and second opinion is different. First opinion and second opinion, that is in the first court and the second court, they are giving the same judgment. Both are convict, like that, they are giving. Then you cannot go further. Because two courts have given the same opinion, right? If two courts have given, the opinion is going to be, why should you ask the third opinion? But if first opinion and second opinion is different, then ask for the third opinion. The first opinion and second opinion is different. Go for the third opinion. First appeal is automatic and the second appeal is discretionary. Then yes, and moreover, the second court may accept the case, may not accept the case. Okay, depending upon the situation. Okay. Now, as I told you, second appeal is discretionary. Supposing, okay, in the lower court, which is taking up a case beyond its competence, lower court beyond its competence, that will be the first opinion. Then they'll go for the second opinion in the next level. Say, let us say sessions court. Whether the person can go to the high court, difficult. Okay, so if the lower court has taken up a case beyond its competence, you just quash it. So now what happens? The sessions court judgment becomes the first opinion. So the person can go to the high court. Second opinion. See, in UPSC preparation also you should follow the same thing. Okay, I would want you to follow the same thing. That is, whenever you are fixing a material, okay, or whenever you are fixing a book, you inquire with your seniors and faculties, okay, twice. First opinion you ask with one person, and then you ask the opinion with the next person. Stop there, freeze it, and start studying. Some people will keep on asking opinion, okay, till the last leg of preparation. Okay, today morning I got a call. The person studied general studies under me in the year 2017. Okay, he calls me frequently just to ask this one question. Sir, for prelims examination is Lakshmikant is okay. For mains examination is Lakshmikant is okay. Or institute book is okay. I've always told institute book itself is okay. If you are psychologically, if you feel that if you want to read Lakshmikant because all other people are reading Lakshmikant, go for it. But nothing else. But he's asking, yesterday question was there, not GS question. Seeing that question, he was asking, sir, these questions, how could I answer from the Lakshmikant? Okay, I said anyway, whatever book you read, these points will not be there because these are questions based on current affairs. Right to Information Act amendment, what will be the impact on the autonomy of institutions? Current, if you have read newspapers, point would have come. Okay, then another question, reforms in election, electoral process, no, and disqualification of MLAs. Okay, what are the changes that should be made in RP Act? Okay, so with the respect to RP Act, no, there was news disqualification of a lot of MLAs was disqualified, MPs disqualified, anti-defection and all came. So you could have easily written if you read the newspapers. Okay, and Rajya Sabha's role, it was highly critical. Okay, last time, the Farmers Act, Rajya Sabha's role. One question. Farmers Act, I discussed you farmers issue. Okay, I hope you are back. Farmers issue, why it is there, food processing, and what is the gain for farmers, from these acts. Okay, those and all is discussed. It's there in current affairs. Two questions in third paper. Okay. So you must know that freeze the material and go ahead with the preparation with current affairs. No, apply that. Instead of that, you rely on the book alone. No, you're not going to clear this examination. At the same time, if you think, sir, if there is some other book where I could find points, no, it's not at all possible. Okay, any doubts in this? Okay, so freeze your material. Don't go for third opinion. First opinion you ask, second opinion ask, you go for third opinion only if first and second opinion is differing. Okay, and take the majority opinion, freeze on the material and start preparing. Likewise, technique, test technique, preparation technique, plan, strategy, everything. Don't keep on, searching for new strategies. That will not be appropriate. Okay. Fine. Any doubts? Okay, statutory is over. Okay, let us take short break, okay, of 5 minutes, and then we will discuss the next one. Okay, core and all can be discussed after the break. Okay. Shall we start? Please enable your videos. No, nobody has enabled your video. Quo warranto. Next is quo warranto means by what authority? Quo warranto means by what authority? If anybody is appointed to a government job, public office, without qualification, okay, unqualified people is appointed, or if the process of appointment is not followed properly, okay, in these two cases, okay, we can file a quo warranto petition to the court of law, and by filing the quo warranto petition, the court will declare the person is not eligible to the office and he will be removed from the office. It is called as quo warranto. So it happened in India that once there was an appointment done by the Congress government to P.J. Thomas. Okay. So he was appointed as the Chief Vigilance Commissioner. Now, to appoint the Chief Vigilance Commissioner, you should be appointed by a collegium consisting of Prime Minister, Home Minister, and opposition leader. Now, the then opposition leader Sushma Swaraj says that I don't want she said P.J. Thomas should not be appointed as CVC, but Prime Minister Manmohan Singh and P. Chidambaram went ahead and they made an appointment to the CVC's office. They made P.J. Thomas as the CVC. Now, a quo warranto petition was filed in the court of law, and the court declared that the P.J. Thomas was not eligible because the process was not followed properly. Because the candidate should be a consensus candidate for Prime Minister, Home Minister, as well as the opposition leader. Okay, so the process is not followed properly. Likewise, qualification also, if it's not there, okay, definitely the person will be removed from the office. Now, this writ is linked to which article? This writ, Article 32, is linked with, quo warranto is linked with Article 16, equal access to public employment. Okay, it is linked with equal access. Now, who can file petition? Okay, telling that a person is holding a public office wrongly. Anybody, any citizen can. Why any citizen can act? Because every citizen have equal access to public office. If a public office is filled improperly, then it is a case of violation of Article 16. So every citizen is affected. Any citizen can file a case. Fine. Article 32 is over. Now let us talk about Article 33. Article 33 talks about restriction of fundamental rights to armed forces, uniformed forces. Restriction of fundamental rights, okay, to armed forces. No, No, it is filed. The quo warranto petition is filed against the individual person. Okay, so the individual person also will not be punished. Will be removed from the post. That's all. If somebody is wrongly appointed to the public office, they will be removed. There is no punishment in quo warranto. So restriction of fundamental rights to uniform forces. I'm sorry, it's not armed forces. It is uniform forces. Okay. So restriction of fundamental rights to uniform forces. Now, what are the rights that shall be restricted to the uniformed forces? It will be decided by parliamentary law. The parliamentary law decides. Okay. Now, what are uniformed forces? Army, Navy, police, paramilitary forces, okay, intelligence agencies, okay, all will be considered as uniformed forces. Okay, and there is also mentioned that analogous forces. Analogous means similar forces to Army, Navy, police. Okay, analogous means similar. The word analogous means similar forces. So any force under the government of India can be, subjected to restriction of fundamental right. Usually, which fundamental rights will be restricted? Civil liberties. Civil liberties is actually Article 19. Okay, why the civil liberties are restricted? In order to have efficient and disciplined work. See, in Article 19, we have right to assembly and right to association. What if police is striking? Police is not coming to work. Okay, you can't help, right? So state police, okay, is not allowed to strike. Army is not allowed to strike. They don't have the right to strike. If you allow that liberty to them, then the entire state system will collapse. Okay, then Article 34, it talks about restriction of fundamental rights during martial law. Already I have discussed what is martial law. Okay. Now, what are the fundamental rights that can be restricted during martial law? It should be done by a parliamentary law, created by a parliamentary law. So far, we have not created any parliamentary law to list down what are the fundamental rights that can be restricted during the martial law. Okay, but remember, it's only parliament law. State legislative assembly cannot create the law. Restriction of fundamental rights during martial law can be created only by the parliament, not by the state legislative assembly. Okay. So now Article 35, it says that for certain fundamental rights, for certain fundamental rights, laws can be created only by parliament, not state legislative assembly. Which are they? Okay, which are the things that not by legislative assembly? Okay, fine. Now I list down the articles: Article 16, Article 17, Article 23, Article 32, 33, 34. For these articles, any law that should be created, it should be created only by Parliament, not by the State Legislative Assembly. But for all other articles, no, even State Legislative Assembly can also create law. We saw, no, in preventive detention laws, laws can be created both by the Parliament as well as the State Legislative Assembly. Okay, so for this, I'll explain one by one. Okay, so Article 16. In Article 16, we see that residence can be made as an exemption, right? Normally, residence cannot be a criteria for giving employment, but exceptional cases, residence can be given as a criteria. But a state government through state legislative assembly cannot give residence as a criteria for employment, public employment. If at all exceptionally a state should use residence as a criteria, the law should come from Parliament. Okay, why it should come from Parliament? Otherwise, every state government will give its residence preference in the public employment. The exceptional case will be considered by the Parliament. Parliament only will create a law and give residence as a criteria for public employment in a particular state. Article 17, abolition of untouchability. To create laws, okay, in order to penalize those who are practicing untouchability, that also should be created in Parliament for uniformity purposes. It cannot be created in the state legislative assembly. Likewise, for human trafficking, slavery, abolition of slavery, bonded labor, forced labor, beggar system, and all, Article 23 also, law should be created by Parliament, not by the state legislative assembly. Article 32, it talks about constitutional remedies. In that, I said only High Court and Supreme Court can create, can listen to fundamental right violation cases. But if a lower court has to be empowered to listen to fundamental right violation cases, who can empower the lower court? Only Parliament, not the state legislative assembly. Okay, but so far we have not empowered any of the lower courts. That is what we saw. Okay, if at all a lower court has to be empowered to listen to fundamental right violation cases, it should be done by the Parliament. Then Article 33 and 34. Okay, restriction of fundamental rights for uniform forces and martial law. Once again, Parliament only should create law. State legislative assembly should not create law. For rest of the articles, both Parliament as well as state legislative assembly can create the law. That is what Article 35 is saying. Okay, so now fundamental rights chapter is over. Now we have to talk about directive principles of state policy. We are moving into the next topic. So the name itself is saying directive principles of state policy. state government policy should be. Directives to the future government. Now, how do I understand the see, now when you say state here, okay, some people will have confusion. State here means both central government as well as state government. Okay, you may think only the country, but directive principles of state policy means it is the directives for both central government as well as the state government. Okay, so what do we understand by fundamental rights? Fundamental rights are having mostly political rights. For example, right to liberty, right to association, right to assembly, and all, no, political rights. Whereas directive principles of state policy, they talk about socio-economic rights. Talk about socio-economic rights. Okay, so what are socio-economic rights? Before that, okay, in case of fundamental rights, we may say that most of the fundamental rights is having political rights, but also we have socio-economic rights. What do you understand by socio-economic rights? The right to equality is a social right. Right against exploitation is a social right. Religious freedom is a social right. So fundamental rights, predominantly political rights, it also has social rights. What are the economic rights in political rights? Article 19, right to occupation, trade and business, right to association, trade union, cooperative societies, that is also economic right. Article 23 and 24 is the economic right. Article 23, 24 is both social right as well as economic right. Okay. Now only one place where you will make is the right of the minorities to establish education institution. In that minorities will be given adequate compensation and aid. They should be treated equally. That is a cultural right and a social right, not an economic right, because that right is given for them to protect their institutions. Okay, so that we have seen yesterday, we saw in elaborately. So don't worry about that. So remaining articles is economic rights, socio-economic rights. So in prelims examination, how they may ask, what are the social and economic rights in the fundamental rights? So you must be able to differentiate. Next, directive principles of state policy, they talk about socio-economic rights. Okay, what are the social rights? First of all, okay, social rights means, see, whenever they are using the word social in the newspaper, social sector, immediately you must know they are talking about food, health, housing, livelihood, education, okay, and then social security. So all these things will come under the social sector. Okay, so DPSP will be talking about these areas only. DPSP will be talking about these things, social sector, social rights. Now in this, you will have a doubt, sir, what is social security? Social security is The support given by the state to those people who cannot support themselves. Social security is the support given by the state to those people who are not able to support themselves. For example, old age people, children, disabled people and all, they're taken care of by the working population. Like likewise, the state also should take care of those people who cannot support themselves, the dependent population. That is called as social security. How the state is doing so? The state is doing so by pension, insurance, okay, transfer payments, okay, like some subsidies, like transfer payments they'll be making. What are the economic rights? Equitable distribution of resources, prevention of concentration of wealth, equal pay for equal work. Okay, so Article 38, 39, like that, economic rights is given in the directive principles of state policy. Now, how question prelims examination they may ask, what are the political rights? That is available in the directive principles of state policy. There are 3 articles. Article 40, organization of village panchayats. Article 44. Article 44, uniform civil code. Article 50, separation of executive and judiciary. Organization of village panchayats, uniform civil code, separation of executive and judiciary. This is done. Okay. Now, what is the next set of difference between fundamental rights and DPSP? Okay, fundamental rights are positive, sorry, negative in character, whereas DPSP is positive in character. As negative, DPSP is positive. Already we have spoken in polity, whenever I say negative, it doesn't mean wrong. Negative means absence of action of the state. Positive means there is action of the state. So fundamental rights expects that the state should not interfere in the individual life. Whereas directive principles of state policy is positive because it expects action from the state. It expects action from the state. As far as negative. Directive principles of state policy is positive. Okay. Now next is fundamental rights is justiciable, whereas directive principles of state policy is non-justiciable. Meaning, if your fundamental right is violated, you can go to the court of law, file a case. Article 32 is there. But directive principles of state policy is not implemented. You cannot go to the court of law. Yes, Vamshi, you are correct. In some of the rights in fundamental rights are positive, but there are few. Vamshi is asking, sir, isn't there positive rights in fundamental rights? Most of the rights in fundamental rights are negative. Some only is positive. Okay, so majorly fundamental rights is negative, we can say, and DPSP is positive. Okay, fine. Next, we have to see why DPSP is not justiciable. Okay, so how we are saying directive principles of state policy is not justiciable. Okay, there are many reasons. First is economic reason. We know that social and economic rights require a lot of money. Social and economic rights requires a lot of money, economy. So at the time of independence, we did not have enough money in order to implement these. That is why we have left it to the future governments. Okay, whenever they have getting money, that time they can implement it. And moreover, see, economic situation is dynamic. Already we have seen this concept. Economy cannot be stable, whether it, your individual life or a country. Okay, sometimes you will have good money, sometimes it will be low. Okay, it's not that every time you will be having a good level of money. Okay, so life is entirely depend on how much you work. Okay, social and economic rights. See, these social and economic rights cannot be made justiciable because, okay, today the country may having good amount of money, but tomorrow if there is a recession, for example, corona pandemic took place, government has to spend all the money in producing vaccine. Okay, so if that such is the situation, it's very difficult, right? So that is why we must know and we must remember that economic criteria is the important reason why DPSP is non-justiciable. Otherwise, government has faced a lot of cases in the court of law. Next is social reason. There are two articles, Article 40 and Article 44. Both are inside the directive principles of state policy because of social reason. So what is Article 40? Article 40 talks about organization of village panchayats. Okay, you tell me what are the social problems in the village area? What are the social problems that we find in the village area? Yes, I want answers from you. Please respond. Caste, very good. Then one more problem. Essay paper. Patriarchy, very good. Patriarchy, very good. So caste system and patriarchy. So these are the biggest problems in the biggest social problem. Agriculture, economic problems, other problems are there. Okay, these are the social problems. Okay, if we are organizing village panchayat in the year 1950 itself, caste Hindus only will come at the powerful position and male only will occupy the position. Now, Ambedkar said, until you are changing the rural social structure substantially, we cannot implement village panchayats at the grassroots level. So we waited for 4 decades, and in 1991, we made village panchayats and local urban self-governments as justiciable one. How was it possible? Okay, we gave reservation for SC, ST as well as women, so that through the tool of village panchayats, we want to effect the change in social structure. Earlier, we thought as such village panchayats is established, it will be misused by casteist forces and patriarchal forces. But now using the very village panchayat, we are trying to change this caste-based discrimination and patriarchal induced inequality. Fine. Next, 44 is Uniform Civil Code. What do you understand by Uniform Civil Code? As all of us know that civil criminal code is same for all Indians, but civil laws related to marriage, inheritance, and other things are different for different religion, and we call it as personal law. Christians have their own civil law, Muslims have their own, Hindus have their own. Okay. But is it good? No, because it is inequality. Okay. We are having different laws for different citizens. And moreover, most of the religious law are unequal, or it is creating or positioning women in an unequal position. So if you are basing your personal laws based on religion, definitely they are going to affect right to equality. So right to equality is affected. Okay. Right to equality is affected. So since it is affected, okay, they are saying we must have uniform civil code, UCC, to create one common civil law for all the people of India. So any modern country, if you see, there is uniform civil code only. Okay. Now, what are the problems? Why Article 44 is kept in directive principles of state policy? So we have several reasons for it. It is a main question. Okay, hurdles implementing UCC. What are the hurdles? First one is, at the time of independence, we had partition. So Muslims were fearing that whether they can follow their religion in India or not. So immediately, if you have gone for uniform civil code, they would have feared that their religion is being attacked. Okay. So to keep calm, okay, after partition, okay, for ensuring the rights of the minorities. Religious freedom. Partition and rights of the minorities, and then religious freedom. Then, uh, you know, there is no equality between religions. There is no common values. Okay, each religion preaches different things. Civil law is based on religion only. Okay, so which religion we can do? If you are to create a uniform civil code, okay, which religion we are going to choose? Okay, or which religious value? If you choose Hindu values, Christians and Muslims will feel that they are alienated. Buddhists, Sikhs, Parsis will feel alienated. For Parsi community, they have a different law. At the same time, if you say, okay, let us take Hindu law, okay, in order to decide the civil law in India, okay, there is a problem. Within Hindus itself, there is diversity. Okay, not all of them are having same property inheritance laws or marriage laws. Okay, culture are different. Okay, so diversity is another problem. What about tribal communities? They have their own form of um, land ownership. Okay, there is no property inheritance or property ownership. Land is collectively owned by the tribals. How come we implement the property inheritance law same way in tribal areas? Because we have scheduled areas, we have to respect the tribal culture, their customs. And some of the places, for example, Meghalaya and Kerala, they follow matrilineal society. In Kerala and Meghalaya, they follow matrilineal society, meaning property will be transferred from mother to daughter, daughter to granddaughter, like that. Okay. So men does not hold on to the property. These two societies, Kerala Nair society and Meghalaya's tribal society. There are some tribal societies which follow polygamy, not only Islam. Okay, some tribal societies they follow polygamy, multiple marriages. Okay, some, for example, in Nilgiris, Toda community is there. Now they are not practicing. Earlier, the Toda community was practicing fraternal polyandry, which means one woman will marry brothers. Okay, just like in Mahabharata's case, like fraternal polyandry, multiple husbands. Okay, there are some tribal communities, multiple wives. There are some tribal communities, family means there'll be group of husbands and wives. Okay, it is not that monogamy. Monogamy will not be practiced. And once again, inheritance of property is different. And there is a problem of dowry as well as bride pricing. Some communities, the bride has to give the dowry. In some communities, bridegroom has to give the dowry. Okay, if you have to marry women, this is happening in Haryana's case, where they have to, in order to equal their sex ratio, they are marrying from other states. They're paying money. This is called as bride pricing. Okay, so which means in marriage, there are certain customs which is not be able to regulate it. Even if government is trying to regulate, okay, government is not able to implement this. Implementation is a big problem. Implementation is a big problem. But see, registration. Of marriages. How many of us are doing registration of marriages? Not all of them. Okay, so usually, you'll have a ritual in your church or a mosque or a temple. That's all. After that, you have to legally register your marriage with the government. Okay, but how many of us are doing this? We are not doing it. But however, certain laws are there. Okay, for minorities. Okay, no need to register their marriage because if it is done by a minister, it is valid. Okay, minister in the sense the priest. Okay, priest, it is valid. That record itself is suffice to prove that you are married. But the point is, whenever marriage, inheritance related to property and other things are brought, very, very difficult. Okay, in implementation. So that is also another problem in the Uniform Civil Code. Okay, then problem of secularism. Okay, if you are touching minorities religion, they will say you are affecting secularism. If you are touching majority religion will say, why are you touching us alone? Change the reform that religion also. Like that, they may keep saying. Then what else is the solution? There must be some solution, to implement the UCC. The suggestion that is offered is slow and steadily make reforms in every religion. There are some doables, there are some non-doable, sensitive things, right? So instead of overnight changing everything, okay, slowly. For example, triple talaq was abolished in Islam. Okay, Sabarimala entry of women into temple. Shani Bhagwan temple, women entry is allowed. Okay, then this Dargah. Okay, Hazrat Moinuddin. I forgot the Dargah name. It's in Delhi. Nizamuddin, I think. Hazrat Nizamuddin Dargah. Okay, there also women entry is allowed. Okay, earlier it was not allowed. Now it is allowed. Okay, so slow and steady. Okay, Christian law, abortion is a sin. Okay, but now Christians also is allowed to do abortions. Okay, they are subjected to Medical Pregnancy Terminancy Act. Any doubts in this? Then, okay, they are also talking about okay, bringing confidence among the minorities. Okay, slow and steadily bring confidence among the minorities. So one day, when each religion is reformed slowly, there will be a position where you can directly implement the uniform civil code. And the other strategy is first consolidate the majority community. Okay, so that is why Hindu code bill was, some people may ask, sir, Hindu laws are reformed completely, marriage laws and property laws. We are talking about perfect equality between men and women. Only Christian laws and Muslim laws has to be amended. Why we are doing that in India? The logic is, okay, first you consolidate the majority community. When majority community is consolidated, when you are created a uniform civil code for majority community, then we can influence or persuade even the minority community to accept the uniform civil code. So India is going in the right direction. Okay, two ways. One is we have consolidated the majority, we have to influence the minority. Second is even in minority religion, whatever reforms that can be done, slowly and progressively should be done. Okay, so there will be one point of time in the very immediate future that we can implement the uniform civil code. Any doubts in this? Yes, of course. So as Mohammed Sadiq is saying that, following religious laws for civil law is absolutely not appropriate because, okay, if you see the religious laws are created in different social economic conditions, different time period of history. So definitely we will not, we will not appreciate religious laws in civil law. Okay, some modern civil law has to be adopted. The question is, what shall be the modern civil law? Yeah, age for marriage is applicable for all communities. Okay, it's not different. Yeah, the one of you are saying that if you're creating uniform civil code, it may lead to loss of culture. See what culture we are losing, we have to see. In implementing uniform civil code, if you are losing the bad culture, okay, bad elements in our culture, bad practices in culture, then it is appreciable. So inequality of women is a bad thing in the culture that has to be rooted out. So good things in culture will not be affected by uniform civil code. Okay, if there is already some good behaviors of marriage, ways of marriage, and way to deal with property relations, that will be followed. So we need not think that culture will be affected. Okay, so initially, yes, of course. Okay, there is one more hurdle in uniform civil code. Let me quote this. uh, Christianity and Islam is ruled by or they have given law by international community. Okay, they are not just in India, but these religions are across the world. Now you cannot make corrections for Christianity and Islam only in India. That is another big problem. Say for example, if you are declaring that in Christianity both men and women should be allowed to be priesthood, Okay, priesthood is something which is decided by the canon law of Vatican. Likewise, Islamic law also it's based on Sharia. Okay, so that is also a hurdle. Okay, I'm not saying that you cannot go for UCC. It is one of the hurdles. Okay, the origin of religion. Can we make changes to a religion which is outside India, which has its origin and functioning across the world? As UCC is a sensitive issue, will government try to implement it because it may affect vote bank party of the party? Yes, true. If UCC is implemented, okay, definitely vote bank will be affected. So those who want minority votes will never do that. That is why I'm saying slow progress, no, will create a situation at one point of time we will be in a position to uh, create a uniform civil code. Yeah, UCC is in those countries which have a single religion, or at least if a country is 98% they're having they can have a uniform civil code. No, see, in case of Pakistan, UCC is there. Only thing is, all their civil code is based on Islamic law. Christian countries, they have uniform civil code, okay, because most of them, there is no problem of diversity, okay, because mostly one people belonging to one religion, they agree with the common things, so there is no issue. Okay, so this is the social reason why uniform civil code has not been in the justiciable part. It is in directive principles of state policy. Government will implement it in the future. Okay, fine. Now, India is also possible. Goa is an example. In Goa, you have uniform civil code. And see, criminal law and civil law is in concurrent list. Remember this. Criminal law and civil law, criminal procedure code, civil procedure code is in concurrent list. So both parliament as well as state can make law. So the state of Goa has successfully implemented uniform civil code. And once again, their cultural differences is not much. Even though Christians, Hindus are there, okay, the cultural differences is not there. Okay, and historically Portuguese already implemented a civil code, which is fine for them. That is the reason. Okay, thank you. So we'll go. Okay, and try to complete it in one session. Yes. So we'll meet at 5 o'clock. Okay, we'll start in a minute. Okay. Okay, so we were talking about uniform civil code. Okay, so that is done. So actually we were seeing that topic, and what are the reasons for DPSP is not justiciable. So economic reason and social reason. And then we have administrative reason. There are 4 articles that has been brought inside the directive principles of state policy because of administrative reason. They are Article 40, Article 47. 47 is prohibition of consumption of liquor. 50, separation of executive and judiciary. 51. This is about our foreign policy. So what is the foreign policy? Mainly, it talks about how to maintain international. So it says that to maintain international peace and security, conduct bilateral relations in conducive manner, foster respect to international institutions. Okay, so foster respect to international. Foster means grow. Okay, we have to develop. So these 4 are the uh, directive principles of state policy, which has been added to DPSP because of administrative reason. We'll see one by one. Article 40, as you know already, it is organization of village panchayats. Okay, Article 40 is organization of village panchayats. Now, India is a federal country, but federalism was experimented newly in the year 1950. You may say, sir, we have inspired federalism from 1935 Act, but remember, 1935 Act never implemented at all because princely states did not accept it. 1939 Second World War started. Okay, so they never implemented it. So when we introduced federalism in Indian Constitution, it was the first time we were experimenting federalism. Now, if you are organizing village panchayats in 1950 itself, from whose power we will be sharing powers with the village panchayats, whether it is a union government or state government, or I'll put it simply, we have union list, state list, from which you will take the powers and share it with the local government. Okay, please let me know. I'm asking a question, from which government? We have union list, we have state list, very good, very good. From state government, very good. So what will happen is, state government will just become intermediary. Federalism is just started. So central government will be powerful, local bodies will be powerful, state legislative assemblies will not be powerful, or state governments will not be powerful. They'll be acting just as intermediaries. So Ambedkar thought that there must be some time in which federalism functions in India and states consolidate some kind of power. After that, we can introduce the village panchayats. That is why it was introduced later. Now, you may be asking, sir, then how come in 1991 we organized village panchayats or made it justiciable part of the constitution? When village panchayats was established as a justiciable part, the constitutional amendment said that powers to village panchayats and the urban local self-government will be devolved by state legislative assembly. The constitution does not separate the powers. He said that we leave it to their respective states. Okay, according to your wish, you can devolve the powers. So some states devolved powers more, some states did not devolve the powers. Okay, then Article 47, prohibition of consumption of liquor and other intoxicating drugs. Now, administratively, liquor industry was, giving more revenue for the government. So suddenly, if you close all the liquor shops, the government will not be able to sustain. So that is why until alternative source of income is established, they said they will continue with the liquor shops. Once again, revenue is the thing. Okay, government has to take the revenue. And one more thing is, those states in which prohibition is there, deaths due to spurious liquor is high in level. For example, Gujarat and Bihar, okay, deaths to consumption of illicit liquor is higher. Okay, so that is why it has to be regulated. So because of administrative reasons, Article 47, the added prohibition of consumption of liquor, it was not made justiciable according to the policy of the government. The government may prohibit or continue the manufacturing and supply of liquor in a particular state. Okay, then Article 50, separation of executive and judiciary. See, in the British time, executive and judiciary was one and the same. There was no different infrastructure or human resource. Immediately after independence, if you want to separate the executive and judiciary, it's not an overnight job. To build a human resource as well as infrastructure separately for judiciary, it will take time. Okay, so they placed Article 50 in Directive Principles of State Policy. And they also said it should be completed as soon as possible. And by the year 1960, we have completed this process. By the year 1960, we have completed this process, separating executive and judiciary. Okay. Now, in certain states, we find that district collectors are called as district magistrate, right? Yeah, Cornwallis did the separation of executive and judiciary, but he did not complete the process. He initiated it. Okay, he said there should be separation of executive and legislature, but that process was not complete. And mostly the district collectors, they had more judicial powers. Okay, so That is what they tried to do. Okay, 1960, the process of separation of executive and judiciary was completed. In some districts, no, the district collector is also called as district magistrate. Why is that? What is the meaning of the word magistrate? Very good, very good. Vamshi, he's an executive magistrate. Very good. Magistrate means maintenance of law and order. The word magistrate means one who maintains law and order. One who maintains law and order. There are two types of magistrates. One is executive magistrate, another is judicial magistrate. Okay, there are two types of magistrate, executive magistrate and judicial magistrate. Executive magistrate, that is the district collector, maintains or does preventive maintenance of law and order. Which means before the crime is taking place, he will prevent crime. By supposing there is a chance of riot situation in a particular district, the district collector enforces curfew. By enforcing curfew, the district collector is able to control the district collector is able to control or prevent the crime. That is why it is called as preventive maintenance of law and order. You may think the SP only maintains the law and order, but remember, the superintendent of police assists the district collector in maintaining law and order. Okay, so it is the district collector who is responsible of maintenance of law and order. Okay. Now, what about the judicial magistrate? He does curative work. He cures. Okay, meaning after a crime is taking place, he punishes the person who has done the crime, and thereby, ensures that nobody else is repeating the same crime. So the judiciary performs curative maintenance of law and order. That is why we have executive magistrate and judicial magistrate. Okay, usually we think that magistrate means judicial powers only. No, magistrate means maintenance of law and order. The district collector is executive magistrate as well as the district collector, whereas the judiciary, they are judicial magistrates. Okay, can any one of you tell me what are the important functions of the collector, primary functions of the collector? They're all aspiring to be district collectors. So I would want you to tell me what are the primary functions of the district collector. You can raise your hand and answer me, or just put it in the chat box. Very good. First is revenue collection. Okay, he is in charge of revenue collection. All IRS officers will be coming under him. That is why the district collector is called as a collector. He collects revenue. Yes, Vamshi, very good. Policy implementation. He implements or commissions the policy. Commissions means initiates the policy in the district. So that is why in some states, the district collector is called as deputy commissioner. Okay, one who commissions the schemes. Very good. What else? Just now we saw he maintains law and order. Okay, the third function is he maintains law and order. Okay, that is why in certain states, the district collector is called as district magistrate. And fourth is the district collector is also personal administrator. Personal. Personal administrator. Meaning he will take charge of the bureaucracy, right from the assistant collector to clerk. Okay, all of them will be administered by him, and he's also a chief crisis manager. Chief crisis manager. Okay. Now, who is the chief crisis manager in a state? The chief minister is the chief crisis manager in the state. The level of the central government, the prime minister is the chief crisis manager. The district collector, being a bureaucrat, is the chief crisis manager of the district, no politician. That is why they say that district collector post, no, it is very important, and it's like a king of a district. Okay, you don't have any control by the politician directly, and that too, if you are managing a district that is far off from the capital, then you have ultimate freedom in making the administration. Okay, fine. Now let us come back to the topic. Okay, that is right. Okay. So the what are the reasons for the non-implementation or non-justiciability of DPSP? Then 51, Article 51 talks about foreign policy. Now, you cannot bind the future governments with a foreign policy. If you make this Article 51 as justiciable, every time you should go for negotiation diplomacy only. Surgical strikes cannot be carried out. Okay. Now, today there is a news that when India has gone for the surgical strike, Balakot air strike, some 300 militants have died, terrorists have died, and it has been accepted by one of the secretaries to the Pakistan government. Okay, a retired person has agreed to that. We don't know how far it is true, but however, the point is we could not have carried out surgical strikes or war with any country if Article 51 is made as a binding one for the future governments. That is why Article 51 will remain in DPSP forever. We will never make it as a justiciable part of the Constitution. So, these administrative reasons, and then to fulfill the promise of people. For example, Article 48 talks about prohibition of slaughtering of cows. So this was added to the directive principles of state policy is because of two reasons. One is, okay, they do not want to make it as a justiciable part because some states opposed the prohibition of slaughtering of cows, like Kerala and Northeast. Okay, so not all states were ready, and moreover, management of cattle is under the state list. It's not under the central list; it is under the state list. So only the state governments can make. So instead of central government making it, they said let the state governments decide whether they can have prohibition of slaughtering of cows act or not. So that is why it was put in DPSP, leaving the discretion to the respective states. Okay. Then in directive principles of state policy, um, even though directive principles of state policy is not justiciable, all the governments, whether it is central government or state government, implements it regularly. What is the reason? Because, okay, votes. Only when a government is implementing directive principles of state policy, they will be re-elected. And that is why Ambedkar would say, DPSP may not have legal sanction, no legal sanction. Which means you cannot go to the court of law in case DPSP is not implemented, but there is political sanction. There is no legal sanction, but there is political sanction. Political sanction means people will vote and decide. Okay, fine. Now, directive principles of state policy may be non-justiciable, but it can be made justiciable. How it can be made justiciable? Point one, you can make a constitutional amendment. Okay, and make it as a fundamental right or justiciable part of the constitution. Okay, can make a constitutional amendment and make it as a justiciable part. Example, Article 21A, right to education. And 73rd and 74th Constitutional Amendment Act. Panchayati Raj. Okay, Article 21A, 73rd and 74th Amendment Act. Then you can make it as a law. For example, MGNRG Act. What have we done? Right to work in Article 41, okay, has been made as a Mahatma Gandhi National Rural Employment Guarantee Act. So that right to work is now justiciable. Article 21A speaks about right to education. Right to education. Okay, so we can create a law, and that through this law, we can make DPSP justiciable. Now, DPSP can be implemented. Okay, so if the government fears, for example, you make justiciable, people will go to the court of law. So it may be a hurdle for the government. So if the government thinks, okay, we don't want people to go to the court of law, at the same time, we try to implement the DPSP. At least we take the initiative. Can they do it? Yes, it can be implemented through schemes. What is the difference between schemes and the act? Act is justiciable, schemes are not justiciable. Yojanas, that is plans, that is also not justiciable. For example, the Prime Minister is saying by 2020 we will try to give, or we are planning to give housing for all. in 4 years. Okay. In case if it is not implemented, you cannot go to the court of law. Ayushman Bharat health scheme, you cannot go to the court of law because they are all schemes. So DPSP may not be made justiciable completely, but government can implement it through schemes. Okay, so there is a scope for it. So any new scheme is coming, how you have to read that? You have to link it with the corresponding directive principles of state policy. Okay, so with respect to Ayushman Bharat, it is Article 41. Okay, likewise, any new schemes are coming, any schemes for scheduled caste, scheduled tribe is coming, Article 46. Like that, you have to relate it to the particular article. That is how you have to read the modern schemes. Okay. Now, what are the characteristics of DPSP? What are the characteristics of DPSP? And as we know, the first point is it is non-justiciable. DPSP can be used to validate a law, but it cannot be used to invalidate a law. I'll put it more elaborately. Can be used to validate a law or action of executive. Cannot be used to invalidate a law or action of executive. Okay. Now, I'll give you an example. For example, the government is running the Tasmat shops, liquor shops. Okay, but according to Article 47, government has to prohibit the consumption of liquor. So now some people file a case. Let us assume that some people are filing a case telling that Article 47 says that prohibit consumption of liquor, but government has opened the liquor shops. Now the court will say, I'm sorry, we cannot invalidate the action of the government because we cannot use DPSP provision to invalidate the action because it is not justiciable. We'll have to wait for the government to change it. Now, can be used to validate a law or action of the executive. Supposing Bihar okay, starts a prohibition of consumption of liquor. So they are starting prohibition under phases. Now, if somebody is filing a case in the court of law, say for example, bar owners and the liquor shop owners are filing a case in the court of law, telling that our livelihood is affected, our work is affected, why the government is going for prohibition, then judiciary will cite Article 47. Tell that said Article 47 says that prohibition of consumption of liquor. So the action of the government is correct. So that is the meaning. It can be used to validate a law or action of the executive, but DPSP cannot be used to invalidate a law or action of the executive. And interestingly, these three characteristics is same for preamble as well as fundamental duties. Okay, these three characteristics is same for preamble as well as fundamental duties. Okay. So now, what is the relationship between DPSP and fundamental rights? You tell me which one is supreme, which one is inferior, or whether it is equal, both are equal. Make a guess. Please reply no. Fundamental rights is supreme. Very good. Kunal, very good. FR is supreme. But whether all the fundamental rights are supreme, there are two DPSPs which are supreme compared to fundamental rights. What are they? 39B, 39C. Okay, now I'm going to give a gift for those people who are going to answer correctly. Okay. So I'm going to ask a question. What is 39B, 39C? What is 39B? What is 39C? What happened to you all? We have already seen that, no? Very important article, socialism. Very good. Ashwin, Sriram, and Vamshi. Very good. Equitable distribution of resources and prevention of concentration of wealth. – 39B and 39C. These two articles are superior, okay, superior to not all the fundamental rights, but only to Article 14 and 19. What is Article 14? Article 14 is right to equality, and Article 19 is right to occupation. Article 14 and 19, they are inferior to Article 39 B and C. Okay, now what is the relationship between DPSP and FR? Harmony between them, or DPSP, and it is a basic structure doctrine. between DPSP and the fundamental rights. Okay, and it is a basic structured doctrine. What is harmony between DPSP and fundamental rights? Directive principles of state policy can be implemented, but it should not violate the fundamental rights. Without compromising on the fundamental rights, directive principles of state policy should be implemented. Okay, done. Now, how the questions they will ask, they'll categorize and ask questions. Now, ideologies. Okay, so there are various ideologies that has been listed out in the directive principles of state policy, like Gandhian principle, then socialist principle, then they also talk about liberal intellectual principles. So they may give a list of directive principles of state policy and ask you to identify what are the Gandhian principle, liberal principle, etc. Liberal intellectual principle. I'll tell you what are the Gandhian principles. Okay, Article 43, protection of, promotion of village industries, cottage industries, and khadi. So Article 43 is a Gandhian principle. Then Article 40, village panchayats, is Gandhian principle. Article 47, prohibition of consumption of liquor. Article 48 is also a Gandhian principle. Okay. What is Article 48? Yes, just now we saw somebody. Just now we saw, no? Prohibition of slaughtering of cows. Prohibition of slaughtering of cows. Okay, so these are Gandhian principles. Okay, protection of environment also you can add, but it was added later. The socialist principles, Article 38, minimizing inequalities. (39A), adequate means of livelihood. See, instead of memorizing independently, if you think like this and remember, it will be easy. 39B and 39C, just now we saw equitable distribution of resources and prevention of concentration of wealth. Okay, then 39D, equal pay for equal work. (42) creating human conditions for workers. (41) social security. So right to food, right to work, right to health, all is covered in the Article 41. Okay, they are all socialistic principles. Then we have liberal intellectual principle. Article 44. Uniform Civil Code. Article 45. Early childhood care. Earlier, right to education was here. When the right to education was made as a fundamental right, Article 45 was changed into early childhood care and education. Okay. Then Article 50 and Article 51. You know what is Article 50 and 51? 50 is separation of executive and judiciary. Article 51 is foreign policy. So these are called as liberal intellectual principles. Any doubts? Political and economic rights. See, in case of fundamental rights, okay, right to everything is a political right. Okay, all are political as well as either economic or social right. So economic rights is in fundamental rights is Article 19, right to occupation, right to trade, right to business, right to cooperative societies. Then Article 23 and 24 is also a economic right. So 19, 23 and 24 is the economic right in fundamental rights. Okay. Then we let us talk about no. See, that is what my dear students, no, don't memorize fundamental rights or DPSP. You will never keep it in mind. In fundamental rights, I told certain fundamental rights are positive, certain fundamental rights are negative. Certain fundamental rights is available against state. Certain fundamental rights is available against individual. Certain fundamental rights is only for citizens. Certain fundamental rights is for foreigners. Like that, that alone you think why it is so, why it is available, why it is character is so. That is enough. Like here and all, liberal intellectual principle, Gandhi principle, socialist principle. Why it is socialist principle? If you think, you will get into your mind. Okay, no need to memorize them. Otherwise, I would have taught you linearly. I'm teaching you in such a way, like this guy, they will ask question in the prelims examination. So the same way you follow it, then it will be easy. So now I must talk about what are the DPSPs that has been amended or added through amendment. 42nd Amendment Act. (39F). Okay. Healthy environment for women and children. 43A. That 39A is there. Free legal aid. (39A) free legal aid. Then 43A. Participation of workers in management. 43. 48. Protection of environment. So they will ask in prelims examination what are the DPSPs which has been amended. They'll give a list of DPSPs and they'll ask for amendment. Only these things you have to remember for protection of environment. Now, Article for not 42nd Amendment Act, 97th Constitutional Amendment, 2012. Okay, so it talks about 43B, formation of cooperative societies. This is amended to the Constitution, formation of cooperative societies. Okay, so you may be asking, sir, in Article 19 also there was cooperative societies. That is negative. When a cooperative society is created, the government cannot dismantle the cooperative society. But here it means the government should facilitate the cooperative societies. Okay, any doubts in this? These are the directive principles of state policy that has been amended. Then they'll be talking about directive principles of state policy or directives outside part 4, that is outside DPSP of the Indian Constitution. Directives outside part 4 of the Indian Constitution. Okay, so Hindi shall be promoted as a official language. Protection of linguistic minorities. In order to protect the linguistic minorities, no? So then protection of weaker section, okay, like SC and SC. Protection of weaker section. Okay, so directive principles of state policy is over. They will not ask question outside this. Okay, so however, whichever way I've taught, the same way you read it in the book. Other information can be cut down. Okay, so they would have given a big list of what are the schemes that has been implemented based on DPSP. That and all can be done away with. No need to read them. Okay, it is redundant. Okay, only current affairs related schemes you must be knowing. Okay, so don't waste time in reading those schemes associated with DPSP given in Lakshmikant. Okay, fine. Next is fundamental duties. Okay, DPSP is over. Fundamental duties. Fundamental duties is okay. Part 4A of the Constitution. Okay, Part 4A. Okay, then article number is 51A. So let us see what are the fundamental duties and then why fundamental duties are not justiciable. So give me 1 minute. Okay, I'll come back and discuss the fundamental duties. Okay, we shall continue. See, fundamental duties, we have 11 duties. Whenever we have to remember a list of duties, a long list of duties we have to remember. Okay, let us talk about this. Okay. Let us compartmentalize. Okay. 11 points into 3 points like that, compartmentalize. When you create subtopics and each topic you remember 3 points, it is easy to remember. 3 is the magic number. Okay, so we can easily remember them. So for example, in fundamental duties, I will create a subtopic for you. First is fundamental duties towards state. That the first duty is abide by the constitution. It's very simple, right? So for any citizen, any country, first thing they will require is abide by the constitution. Okay, so you must remember Donald Trump. Okay, here. Okay, it's the best example for abiding by the Constitution of America. Okay, so Constitution of America talks about, constitutional methods. You can protest, demonstrate. You have freedom of speech and expression. We have court of law. You can go to the court of law and everything. It doesn't ask for riot situation. In fact, America is known for cradle of democracy, more professionally conducting democracy. Seeing the pictures, I was disturbed that because I have been in many of the classes talking about the best, how best Americans do their business, especially world constitution. No, when I'm talking about that, I would always refer to the best thing in the UK democracy and the US democracy. But everything has been shattered in one day. Okay, that is because Donald Trump abided by the Constitution of US. Any citizen come back. Any citizen of any country, they have to abide by the Constitution. Meanwhile, we'll be having World Constitution class. Okay, so whatever I teach in World Constitution class, I take only one class, 2.5 hours class for World Constitution class. 2 questions have come directly from the class lectures itself in the examination. Okay, yesterday. Okay, the question on Speaker's office compared with the UK and India, the judicial appointments comparison with India, it has directly come from the class notes. Okay, so other areas also, if you have seen yesterday's GS paper, you will understand that most of the topics have already been discussed in the class. Okay, just by the discussion you could have answered. Yes, see how much our people can we vote. Okay, can a president? My question is, you see the number of votes with which Joe Biden win is less. Agreed, very less margin. But can a president instigate riot? Can a president ask for entering into the capital? See, it is a blatant murder of democracy. It is the president who has to maintain the law and order. It is the prime minister, it is the chief minister who has to maintain the law and order. You cannot give any other excuse. Okay, just because you want to retain power, just because the margin is less, will you ask, see, when 49% of people has voted for him, 51% of the people have voted against him. That is also there. No? So he has to accept the democracy. Okay, and genuinely, see, in electoral politics, you accept defeat to come back and win again. So why can't he come back in 2024? Maybe his age is not there. Okay, but a genuine politician should accept defeat and allow for smooth transition of power. You cannot play like a child. Okay, in my home it will happen. Okay, whenever my brother's son is coming to my home, okay, my son will never touch toys normally. He will be playing by himself, speaking to me. But whenever my brother's son is coming, then only he will take the toy and keep it with himself. He will not give the toy. Okay, now what Donald Trump is doing is a child. Okay, immature behavior. Okay, it is condemned across the world. Okay, until this, okay, he fought in the judiciary, nobody questioned. He had every right to fight in the judiciary, democratic way. But when you are asking the people to go for a riot, and they have found out bombs and all, pipe bombs, which means everything is premeditated. Okay, they have planned it to be done. Okay, so that is why I'm saying that what Donald Trump is wrong. He did not abide by the Constitution. If you read American Constitution, it gives you ample scope for protest. It gives ample scope for protest, demonstration. Now in USA, even if you burn the national flag, You will not be penalized. It will be treated as freedom of speech and expression. Okay, but that doesn't mean that you have to hurt others, because your liberty stops when others' liberty is beginning. Okay. Anyway, so one has to abide by the constitution as a normal citizen. Okay, so not only abide by the constitution, you have to respect the national symbols, abide by the constitution, respect the national symbols, anthem, etc. Okay, so all national, you have to do. It's natural, right? Okay, so if you are a citizen of the country, you have to respect it. Now here, respect means, there is some kind of meaning. For example, it happened in India that once, people were singing Janagana Mana, the national anthem. Shashi Tharoor was present there. Okay, he found that people were not enthusiastically singing the song, so he said, stop. Okay, don't sing it. And he asked people, take your hand, keep your palm on your near your heart, and then you sing the national anthem. And everybody did it. And after that, one fellow, of course, BJP, they filed a case in the court of law. Shashi Tharoor has violated the national anthem. He has disrespected the national anthem. Where is the respect? When you are singing the national anthem without knowing the meaning, without knowing what it conveys, then it is wrong. But when he is asking not sing the national anthem with the true spirit, it is not violation of the national anthem. So when you say respect national symbols, it's not mere respect. Okay. Most of you are Tamil here. I think some other state people also there. I don't know. Maybe in regional films, this scene you would have seen. Okay, that there will be army group. They'll be they'll be involving in a parade. At the end of the parade, they'll be singing the national anthem, Janagana Mana. They'll be singing, and the hero's sister, she'll be raped by the terrorist, and the terrorist will come and drop her before the army contingent. It's a Sharath Kumar film. You might have watched, you might not have watched. Okay. Now, I don't know Sharath Kumar or Vijay because both are nationalistic. They act nationalistic films. Now, what happens is the terrorist will come so near, but just because the national anthem is being sung, the army people will not move an inch. They'll wait till the national anthem is over. After the national anthem is over, they will rush, and before that, the terrorists will flee, and the sister of the hero will die. Is this nationalism? That is the question. Why you salute the national flag? Why you sing national anthem? To protect and uphold the people of India. The national symbols, the national anthem is the representative of people of India. Now, when people of India is suffering, when people of India is affected, you cannot fly the national flag over the dead bodies of Indians. Just like what Donald Trump did. Okay, you cannot do that. Okay, so that scene, I oppose completely. Your nationalism is capture the terrorist, protect the women. That is the reason why you have been in the army. Okay, simply saluting and singing the national anthem is not the respect that you give to the nation. To be open, not to be frank, when you kill your brothers and sisters, when you mob lynch your brothers and sisters, and you say that you are a nationalist, you are a patriot, You are not a patriot, you are a bigot. You are merely giving respect to the symbol, not the essence of the symbol. Okay, fine. Now, next is you have to cherish the noble ideals. Cherish the noble ideals that inspire our freedom struggle. What are the noble ideals that inspired our freedom struggle? There are a lot of noble ideals. Okay, ahimsa, satyagraha, self-determination. But I'll come to this point later. But whatever noble ideals which inspired our freedom struggle has to be cherished. Then protect the sovereignty, unity, and integrity. Protect the sovereignty, unity, and integrity of the country. This is the third fundamental duty. Okay, fine. Now, what is the next set of duties? I would call that as derived duties. Now, for your memory purposes, I'm doing this derived duties. Okay. So, what do you mean by this? Okay, derived duties. You can derive the next three duties from the third point: protect sovereignty, unity, and integrity. Now, you tell me, guys, when there will be danger to sovereignty? Leave the normal points. Highest most damage of sovereignty when it will happen. Please reply me in chat box. Okay, separate state administration, or you want to create a new country. Very good. War. Very good. War. Very good. War also. So whenever there is a situation, there is a war, external war or civil war. Okay, the government can ask you to render services to protect the sovereignty of the country. The government may ask you to render services. You should render services. So that is why I'm saying it is derived duties, derived from the third point. Very good. External occupancy also, to fight that. Whenever the government is asking to render services, you have to do that. Next point. Okay, unity of the country. How we can ensure the unity of the country? I'll ask one question. The word unity in preamble comes after which word? The word unity in preamble comes, very good, fraternity. Good. Very good. So develop a sense of brotherhood. Develop a sense of brotherhood. Okay, so It also involves racist practices derogatory to women. Develop a sense of brotherhood, okay, and racist practices derogatory to women. Okay, fine. Now, integrity. What is the meaning of the word integrity? Anybody? We have seen already in preamble. What is the meaning of the word integrity? Let me see whether you are remembering. Undividedness, very good. Or wholesomeness, do not divide. Okay. Now, how this integrity can be protected? How we can ensure the country is not divided? By respecting the heritage of composite culture. Respecting the heritage of composite culture. Now, I have to give explanation for two words. What is heritage? Heritage means whatever you are inherited from your forefathers. Whatever we have inherited from our previous generations is called as heritage. So what is composite culture? I'll give examples for that. Before that, composite culture take down. Composite culture is a culture in which we can find all the sub-elements of all the culture. Or it is a culture in which you will find the elements of all the subculture. It is a culture in which you will found the elements of all the subculture. Now I'll talk about this. People from South India go to Amarnath Yatra or Amarnath Shrine. They visit Amarnath Shrine. Kasi, they visit. Rishikesh, they visit. What is the link? People from North India, they visit Rameshwaram, which is in the southern part of Tamil Nadu. Okay, the last most district, almost the. What makes it to do so? Okay, because there is a cultural link. We have a link. And I would like to give the example of Sufi movement and Bhakti movement. Hinduism is a polytheistic religion, multiple gods. But Bhakti movement, it talks about devotion to one God, where they have inspired this devotion to one God. And moreover, Bhakti movement does away with the primacy of priest. Usually Hinduism, priest must be there to communicate between a normal person and the God. But in case of Bhakti movement, there is no gap. Directly the devotee can talk to the God. Example, Andal. Okay, Tamil Nadu, no, we have a big history of Bhakti movement. Basavanna of Karnataka. Okay. The inspiration is from Islam. Islam is monotheistic religion. There is no primacy of priest. Now, if you go into the mosque, no, when the Maulavi makes a prayer, okay, he will sit along with the people and make the prayer. There is no primacy of priest. Likewise, Sufism, all over the world, in Islam, dancing and singing is a haram. It's a taboo. You should not, haram means you should not follow it. But Sufism uses dancing and singing to achieve godness. And where they have inspired this from? Sufism is the unique form of Islam from India. Of course, Persian influence is there. But Where this is inspired from? It is inspired from Tantrism of Hinduism. And if you guys ask me, sir, what is Tantrism in Hinduism? You must go to Isha Yoga. Okay. Yes, what they're teaching there, no, in Isha Yoga, the dancing, the Shivratri festival and all, music, dance, okay, in that, finding ecstasy and oneness with God. So this Tantrism of Hinduism has inspired Islam, and Sufism has been created. The culture of hospitality. Across India you go, all the cultures receive their guests with welcome. Likewise, festivals also. For example, Pongal we are going to celebrate. Okay, first of all, happy Pongal to all of you. I wish. Now, Madar Sankranti in Andhra Pradesh, Bihu festival in Assam, and North India also, the Holi festival is a harvest festival. The name may differ, the time you celebrate may differ, but all are harvest festivals. That is what we call it as composite culture. Okay, there is unity in diversity. Food habits. Okay, so Indian food meant spicy. Okay, what spices we use may differ from North India to South India. Okay. Day before yesterday, I was in academy. I ordered a South Indian meals to eat. But when I opened the parcel, there was a chapati in it. How come chapati came into South Indian diet? Don't know. When I've gone to interview to Delhi, I ordered I've had North Indian meals. There is this rasam, papad. Okay, of course, papad is common, but South Indian papad. Now, how come rasam came into the North Indian dish? Composite culture. We have influenced each other. Okay, so there's nothing, purely you can call it South Indian and North Indian. There is a mix of things. Okay, so if you go to North India, people come to South Indian restaurants to eat dosa. And every day evening, in Chennai, UPSC aspirants, they throng the Pani Puri stalls, okay, to eat Pani Puri. It may be sound funny, but this is what we call it as composite culture. Every culture, every religion, okay, has mutually influenced, and we have started living together long back. Okay, there is some commonality that we can find in each and every aspect. That is what they are saying, respecting the heritage of composite culture. It is not new. You have to respect, you have to believe, not that believe, you have to know and understand that we have inherited a composite culture, a culture which is mutually influenced, not an exclusive culture, but our culture is inclusive. We are all inclusive. We have started living together despite of our differences long back. Don't emphasize on the differences now. That is what they are saying, respecting the heritage of composite culture. That is the meaning of composite culture, a culture which has the elements of all subculture. Okay, so now Tuesday, in our academy, we have planned to wear dhoti for Pongal. Okay, that also there is a element of equality, right? Or I should say composite culture. Indians usually have a different type of dress. Okay, we have a big fabric. Fabric will be wrapped around the body, whether it is sari or dhoti. But Westerners, they know the art of stitching. So their dresses will be completely different. See, you may say, sir, kurta, pajamas, that is Indian. They have come from Persia, Central Asia. Okay, Indian way of dressing is, wrapping a fabric around our body because it's commonality. Okay, fine. I can go on quoting, there are many things. Okay, for paucity of time, I'm not doing it. Okay, for example, caste system, once again. Okay, so even though caste system is bad, you can easily find out whether a person is from India or not. Okay, because they'll tell you a caste name. Even Christianity and Islam in India has adopted caste system. So now the point is you have to respect the heritage of composite culture. So from the third point, you can arrive at the fourth, fifth, and sixth point. Next set of points is duties towards surrounding. Duties towards surrounding. Okay, that is, you should not damage the public property. Now protect the environment. Okay. Don't damage the public. Okay, I've written this is some people don't damage. It's not damage the public property. Don't damage the public property and protect the environment. That is the next set of duties. The next set of duties is duties towards oneself. Strive for excellence. You have to strive for excellence in individual pursuits as well as collective pursuits. Whatever you do individually and collectively, you have to strive for excellence. Do the best. And you may be saying how it is duty towards the country. When you do best, you are contributing to the country. Already, I need not explain to you guys, you are doing your best. Okay, despite of searching a job and settling for smaller things, you are trying to take up civil service examination. And you know, when you take civil service examination, it's not only a short-term commitment, it's a long-term commitment. That during disaster and crisis and all, you want to work for the people. Okay, so not only you are excelling, you are making the country to excel, contributing to the society. Now, I just want you to tell one more thing, when you are trying for UPSC exam, try for all other exams. Which means apply for TNPC, SSC, banking. But remember, don't prepare for them. Prepare one exclusively for UPSC. If you are sincerely preparing for UPSC, you will be clearing other exams also. They have a subset of your, some specific preparation a week is enough. Okay, I have, after starting UPSC preparation, within 2 years, I cleared Postal Assistance, Inspector of Post, Food Corporation of India, SSC I have cleared. Okay, and Deputy Manager, that is Deputy Manager in the Banking PO, both in SBA as well as IBPS I cleared. Okay, so Group 2 of TNPC, I cleared Cooperative Society, Inspector, Senior Inspector in Cooperative Societies, Agriculture Marketing Officer. Okay, I did not take up these posts, okay, because my ultimate destination for UPSC. That is why I resigned from Cognizant and came. And I had other plans in life. Okay, in case if not IAS, I know other plans. Okay, so I am not going to reveal. They say no, your plan should not be revealed. Okay, so future, and I have some plans for it. So I do not want to get into a small square. But remember, the point I'm trying to convey is when you prepare sincerely for UPSC for 1.5 years, definitely all other exams you will be easily able to clear. So apply all exams, don't prepare for them, prepare exclusively for UPSC, automatically they'll clear. After 2 years or 3 years, then you can exclusively prepare for other examinations. Okay, so that is very important. And moreover, why am I asking you to take other exams is, you will find simulation. Right now you are in online class. Okay, test taking and all you are doing at home. You don't know what is the real atmosphere of test taking. You will be taking the test in the month of May, very hot climate in Chennai. Okay, and moreover, you will be put in government schools where there won't be toilet facilities. Okay, especially for women, it will be very difficult. Okay, so you have to manage that and all. Okay, then you won't have proper drinking water facility. And sometimes you will be made to sit in a place where there is no fan. Sometimes you will be put in a class where there is no light, the tube light is not there. Okay, even windows you cannot open, government schools. You have to sit in dark and write. Sometimes you will be sitting near, in one of the prelims examination, my second prelims, I remember, I was sitting in the first bench. The first bench was, close to the wall, and right side to that, there was a dustbin, which was not cleared for, I think, for months. Okay, so much of garbage, and it was stinking there. And you just imagine, I was sitting in the corner near the dustbin, and I was taking up the prelims examination. Okay, now these kind of experiences you will get only when you take the many exams, even the smallest group. Let it be TNPC group 8 group, even the smallest of examination you don't want to join. Attend it for the purpose of simulation, taking the examination. That will keep you in spirits. Okay, and it will prepare you to take up any situation, whether it's preliminary mains. You see, mains examination, nowadays mains examination, they are providing a lot of facilities. UPSC, thanks for UPSC, they have reformed a lot. Okay, in our times and all, we will be sitting and writing in a bench, which will be, seesawing. Okay, and that the invigilators will be, speaking about the cinema they watched in KTV the day before. That day KTV, that time and all, KTV is very famous. Okay, they put a lot of cinemas. Okay. So these are issues that you will face. Okay, so for real-time issues, take a lot of examinations. That is my sincere advice. Okay, then next is you must develop a spirit of inquiry. Humanism, spirit of inquiry, humanism, and scientific temper. So what is spirit of inquiry? India, there's a big problem of blind beliefs and superstitions. So Indira Gandhi wanted, people, she said, don't remove all the traditions. She said, you should ask what is good tradition, what is bad tradition. Good tradition follow, bad tradition do it away. For that, you should have spirit of inquiry. When something is told to you, you should ask why we are doing it. If it is good for you, good for your family, good for your caste and religion, fine, do it. But if it is hurting some individual, hurting others, then you have to drop that tradition. Okay, so that is the reason why spirit of inquiry must be there. Humanism. Okay, this concept has been dealt in preamble itself. In traditional societies, social institutions are primary compared to individuals, right? Social institutions such as caste, religion is primary. So even for the benefit of them, honor killing should be carried out. But humanism says that human beings are primary. The caste, religion, and politics, everything, family, everything should contribute to the individual, help the individual to survive. So that is what we call it as humanism. Scientific temper. So what do we know by scientific temper? Scientific temper. Scientific temper is believing in something or accepting something only after a proof, or at least logical reason. Not everything can be proved. Okay, so you should have a reason to believe something. Okay, science is saying that you have to need evidence or at least logical reasoning. So accept something only after applying the scientific temper. And finally, the new fundamental duty is added, that is, you have to educate your ward. Ward means children. So who should do it? The parents and guardians should educate their children. Now this is newly added fundamental duty, 86th Constitutional Amendment Act, 2002. Okay, It was added. Now, next topic that we have to see is fundamental duties are non-justiciable. Why? See, abide by the constitution, they are saying, which means you have to accept the constitution. You may say that, I believe in the constitution, abide by the constitution, but really in your mind, whether you are abiding by the constitution and constitution principle, nobody knows. You may have your own thought, right? Same way, cherish the noble ideals. Okay, it is enough we cherish the ideals, need not follow it. What do you mean by cherish? You should feel happy about, okay, the noble ideals. Now, how could one identify whether you are cherishing it or not? Okay, so it is difficult to ascertain what happens inside the mind of citizens. You cannot ascertain. Okay, you cannot 100% sure. Okay, fine. Then we have a lot of words like humanism, noble ideals, scientific temper. Okay, so now I have explained to you what is a scientific temper, but it can be subjected to multiple interpretations. When something is subjected to multiple interpretations, you cannot make it justiciable. Okay, you can make something justiciable only when it is very clear. Okay, they will say that law should be lucid, meaning law should be very clear, very specific. Okay, you cannot have a wider term. Okay, so wider terms are there. Okay, and moreover, all are positive in nature. Fundamental duties is positive, which means it accepts positive action, accepts action from the people. See, there is a provision protect the environment. Okay, it accepts all the citizens to protect the environment. Can we go and check whether all the citizens are protecting the environment? No. And moreover, how many of you doesn't use any vehicle at all? Any automobile at all, except cycling? Okay, petroleum or diesel vehicles. Okay, how many of you never use it in life? All of us use. And you use a vehicle, definitely you are polluting the environment. Okay, so when things like that, there protection of environment, ideal thing is there, and you are expecting all people to do it, it is very difficult to see. When you are asking people not to do a particular thing, it is easy to track them. For example, 100 people are there. You're telling that, don't litter the public. 2 people are doing it. You can arrest them. What if 98 people are doing it? Only 2 people are following the law. You cannot. So you must know that it is positive in value, so we cannot make it justiciable. And moreover, fundamental duties are educative in nature. It tries to tell people these are the values you should inculcate. These are the values that you should inculcate. So the government is just communicating, this is what we expect from you. Moreover, we know that India is a traditional society. And the fundamental duties expects modern values. Humanism, spirit of inquiry, scientism, okay, all are modern values, but the society is still traditional. So when you make it justiciable, most of them would be in jail only. So we can expect the society to transform only. We cannot implement the fundamental duties as such. Okay, fine. Yeah, you are true. It's like Ashoka's Dhamma policy. Okay, demanding the citizens of certain duties. Good. That's a good reference. Very good. And any doubts in this? Okay, done. Okay, so my portion I've completed. Okay, I wish you all a very good preparation this year. Okay, prepare with positive mindset. Okay, the quality only fundamental rights, DPSP, and fundamental duties are difficult part. I think I made it easier for you. Okay, now I would wish that you complete all the subjects. Okay, give concentration all not only in polity but all other subjects. You try to make a balance. Don't miss the tests. Regularly attend the tests. Even if you don't prepare, parallelly you have to attend the test. Then only you will be able to clear in the first attempt. Okay. Otherwise, thinking that after completing the syllabus only I'll take the test, it will backfire. Okay. So don't skip the test. Don't skip the preparation. Don't skip the class. Okay. Okay. So all the best to you. Before that, there are two questions that you are asking. Traditional society you are asking to repeat. So India is a traditional society where superstitious belief is there. Blind beliefs are there. People are not scientific. People do not place humans at the center. They keep caste, language, religion at the primacy. So the fundamental duties is asking to keep human beings at the center. Okay. So now if you apply the humanism principle and you say that it is justiciable, many of the people has to be in jail. Okay. You cannot apply that as a law. So that is why fundamental duties is just educative in nature. Okay, done. All the best to you. Welcome. So let's wind up the class. Okay, so since I've finished the portions. Thank you. Yeah, happy Pongal. Thank you. Happy Pongal to you all. Thanks. Thanks. Thank you. Thanks for the comment, Manisha. Thank you. Thanks for continuously enabling the video. Okay, because that helps us a lot to understand whether you're listening or not. Thanks for that. Okay, I'll take leave. Thank you all.